Hello and welcome to Reading Decisions. I'm Diana, a lawyer in Nova Scotia, reading decisions issued by our courts in various jurisdictions around the country of Canada. Our case today comes from the Supreme Court of Prince Edward Island, Gosbee Estate 2025 PESC 47, as accessed on the CanLII database. As always, any mispronunciation or errors are my own. No advice is given here of any legal nature. And we're going to read through the case and kind of see what happens in an estate closing. People have heard of that term before. On Prince Edward Island, as every place is slightly different as you move through different territories and provinces. So let's get into it. How is a reasonable compensation for an executor determined? That is a sole issue in this matter, as all other estate disbursements have been shown to be proper and reasonable. Vaughn Mary Gosbee passed away August 2022. Letters probate were issued in October that same year. Her estate consisted of a plot of land in Guernsey Cove, principal residence in Montague, a motor vehicle, an investment portfolio with TD Wealth, 3 GICs, several TFSA accounts, and 2 bank accounts. She left a simple will, 7 specific bequests, 5 monetary, 1 motor vehicle, and 1 plot of land. Directions to sell her principal residence and add that money to the rest and residue of her estate to be divided amongst 3 residual beneficiaries: the Queen Elizabeth Hospital Foundation, the Kings County Memorial Hospital Foundation, and the Murray River Baptist Church. The executors come to this court seeking a final passing of accounts. The final passing of accounts is the final paragraph in the life story of the testatrix. It has significant legal consequences for the creditors of the estate. See Section 22 of the Probate Act, RSPEI 1988, Cap P21, and as the court's stamp of approval on the executor's handling of the estate. The passing of accounts is a judicial audit wherein a judge has a duty to scrutinize the handling of the estate to ensure the executor's compliance with the will, the Probate Act, and that all disbursements and payments were proper, appropriate, and reasonable. A judicial audit is not a forensic audit. A judicial audit will be of necessity more detailed when there are specific objections with which to deal. However, the agreement of all beneficiaries does not relieve the court of the duty and obligation to scrutinize the estate to ensure that all expenditures are appropriate and reasonable. Bellamy v. Thompson, 2024, ONSC 309, at para 43. In this case, the executors have completed their tasks, paid all debts, dispersed all specific bequests, and obtained a Revenue Canada clearance certificate. The only issue remaining is the quantum of the executor's commission, which in turn impacts the balance of the rest and residue to be divided amongst the residual beneficiaries. The starting point must be Section 11 of the Probate Act. The heading of Section 11 is Remuneration of Personal Representative. Remunerate, according to the Canadian Oxford Dictionary, 2nd edition, means to reward or pay for services rendered, or to serve or provide as recompense for toil. Section 11 reads as follows: No personal representative shall make any profit out of any estate, but the court may allow him, on the gross amount received, a reasonable commission not exceeding 5% over and above all necessary expenses. At common law, trustees were not permitted to profit from a trust. Section 11 alters the common law by allowing a reasonable commission. A reasonable commission, under Section 11, is not a bequest. The question of the amount of reasonable compensation is at the discretion of the court. The onus to show that all expenditures are appropriate and reasonable lies on the party seeking the passing of accounts. The section also puts a ceiling of 5% of the gross amount received. It would seem to me to be common sense that a 5% commission would be reserved for the most complicated cases involving more skill and time. Finally, given the word remuneration in the heading, there must be some connection between the time, work, and services rendered by the executors and the amount of compensation. In my view, the goal of setting reasonable compensation under Section 11 is to arrive at a compensation which is fair to both the executors for their time, work, and skill on the one hand, and beneficiaries on the other. In this case, the executors initially sought a commission of 5%, $63,198, but reduced their claim to 3%. To test the reasonableness of this claim, I would apply what I would call a modified version of what has been called the 5 factors test. This test has been used in Canada for more than 100 years, and its longevity appears to prove its usefulness. Re Toronto General Trust Corporation and Central Ontario RW Co. 1905, 6 OWR 350, Ontario HC. Estate of Grace Soliski 2003, MBQB 161 at para 47, and Bellamy v. Thompson Supra at para 165. The 5 factors are 1. Size of the trust, 2. Care and responsibilities springing therefrom, 3. Time occupied in performing the duties of executor trustee, 4. Skill and ability displayed, 5. The success which attended the administration of the estate. To those 5, I would add a catch-all 6th factor. That would be any fact of a particular case which the court considers relevant to the issue of fairness as between the executor and the beneficiaries. Application to the case at bar. Size of estate. The executors claim a percentage of $1,263,975.54, which they refer to as the realized estate. This is not a small estate, but neither is it a particularly large estate. It was not a complex estate. It consisted of a motor vehicle, a plot of land, several investments, bank accounts, and a principal residence. Time. There are tasks that all executors must perform. Those tasks include such things as putting together an inventory of the estate, meeting and instructing lawyers and accountants, obtaining letters probate and clearance certificates and the like. The executors state that they spent a significant amount of time as executors dealing with the estate. They did not provide me with a breakdown or estimate of the time spent. There were no bickering beneficiaries with which to contend, no court challenges to face. There was no complex tax issues, nor anything that would require a large expenditure of time. The only task I see might be beyond the usual executor's tasks was the preparation of the principal residence for sale. In order to sell the principal residence, the executors had to spend much time cleaning the residence and making repairs. Therefore, they had to contract for the work to be performed to make the property sellable. In addition, they had to select and deal with real estate agents and negotiate a sales price. Skill and ability. There was no particular skill set possessed by the executors that would impact the estate. The executors were wise enough to let the investments held by the testatrix at the time of her death remain safely invested so as to grow the estate. Success. While 2.5 years might seem like a long time to handle an estate, it is fairly common knowledge that it takes a long time to obtain a clearance certificate from Revenue Canada. When that is taken into account, the estate moved along at a reasonable rate. The executors paid the bills, taxes promptly, and avoided any interest or penalties. They were successful in bringing things to a conclusion in approximately 2.5 years. Overall, this was a fairly simple estate of a moderately large size. Utilizing only the 5 factors, I would be inclined to set the executor's commission in the range of 2 to 2.5%. There are, however, 3 factors that are relevant to the issue of fairness as between the executors and the beneficiaries that lead me to conclude that a commission of $37,900, 3%, is fair compensation in the circumstances. Firstly, the testatrix appointed no less than 4 executors. That, I will say, is unusual. It was, however, her right to do so. But appointing 4 executors meant that all decisions had to be made by 4 people, all documents signed by 4 people, and everything, in short, took more time. No doubt, because there were 4 executors, some work was duplicated. However, that was a choice of the testatrix. Second, as the goal is to establish a commission that is fair to both the executors and the beneficiaries, the consent of the beneficiaries is something to consider. It will not relieve the court of its obligation to make an independent assessment as to what is fair and reasonable. I also wonder whether the beneficiary's consent was fully informed or simply a matter of not wanting to look a gift horse in the mouth. Nonetheless, the 3 beneficiaries had the affidavit of the executors, including the statement of receipts and disbursements for the estate, and they approved the disposition of the funds and agreed to an estate administration fee of 5%, $63,198. If the beneficiaries of the estate were content with 5% commission for the executors, they should be more than content with 3%. Finally, the executor's decision to seek a percentage of the realized estate as opposed to the gross amount received meant that they didn't take into account the value of the motor vehicle, $50,000, and the plot of land, $15,000, in their calculations. When these items are included, the percentage claimed by the executors is closer to 2.8%. Taking these circumstances into account, I believe the executor's fee of 3% of the realized estate, $37,900, is reasonable. I would therefore grant the order for final passing of accounts as presented, with a commission to be paid to the executors of $37,900 to be divided amongst them. Justice John K. Mitchell. Again, I'll make sure to link the case, and you can have a look at the decision and the cases cited as reference yourselves. Feel free to make good use of those resources. Take care. Till next time.